Hello. So I'm now back with SONY's motion for continued sealing. This is 8 pages long, so be interested to see what they have to say. Because they're the kind of, I think, one of the main sort of third parties that people are interested to hear from, because so much has been made of them, what they know, what they saw, but we haven't really seen or heard anything about that. So this is something I've been waiting for this one. So let's go. Dear Judge Lyman, we write on behalf of non-party Sony Pictures Entertainment SPE. Pursuant to Rule 4B of Attachment A to the Court's individual rules, to request that the Court maintain under seal certain portions of documents filed in support of 1. The Wayfarer Party's motion for summary judgment, 2. Plaintiff Lively's opposition to the Wayfarer Party's motion for summary judgment, 3. The Wayfarer Party's opposition to Plaintiff Lively's motion for spoliation sanctions, and 4. Third-party Plaintiff Abel's opposition to third-party defendant Jonesworth's motion for spoliation sanctions. Okay. SPE has carefully evaluated the sealed documents and requests that the Court seal a very modest amount of SPE material filed in connection with the aforementioned filings. 1. Narrowly tailored portions of deposition testimony texts and emails of SPE employees. 2. Highly sensitive terms of a commercial agreement between an SPE affiliate and certain of the Wayfarer parties. And 3. Personal phone numbers of SPE employees. No presumption of public access attaches to the SPE material because none of it is relevant to this Court's judicial function in considering the summary judgment and sanction motion with which the material was filed. SPE's request for sealing should be granted for this reason alone. At most, the SPE material plays a negligible role in the Court's exercise of its judicial function. Any presumption of access that could attach to the material, therefore, is low and easily outweighed by 1. The privacy interests of SPE's employees in the testimony, texts, and emails at issue, and 2. SPE's commercial interests in protecting the highly sensitive financial terms of its production, financing, and distribution agreements. Given the, at best, negligible relevance of the SPE material to the filings before the Court, any opposition to this sealing request would not appear directed at advancing this case, but rather at harassing or embarrassing non-parties to gratify private spite or promote public scandal on matters irrelevant to the issues before this Court. The Court should grant SPE's sealing request in full. Okay, it's strongly worded. The SPE material. The SPE material and grounds for sealing are summarized in the following table and explained in further detail below. I like this layout. I like this. Okay, so Declaration of Alexandra Shapiro, Exhibit 12. Not relevant. I mean, they're all not relevant, so I won't go through that. We've got the Shapiro Declaration, Exhibit 23, Memorandum of Law at 47, Rule 56.1 Statement, Exhibit 72 of the Shapiro Declaration, Exhibit 120 of the Shapiro Declaration, Exhibit 179 of the Shapiro Declaration, and Exhibit 196. Okay. Let's see. Exhibit 197 of the Shapiro Declaration, Exhibit 198, and then Exhibit 243. All but the bottom one are just for non-relevance. The last one, Exhibit 243, is for personally identifiable information, personal phone numbers. Lively's opposition to defendant's motion for summary judgment. Sorry. So we have Counter Rule 56.1 Statement. Okay, that's from Lively. Exhibit 23, Exhibit 196, Exhibit 97, Exhibit 197, and then Exhibit 198. All because they're not relevant and highly sensitive. Declaration of Gottlieb, Exhibit 96. The expert report of Jennifer Trade, not relevant. Gottlieb Declaration, Exhibit 17. Lively's Counter Rule 56.1 statement. Not relevant to the performance. Gottlieb's Declaration, Exhibit 124, not relevant. And then we've got defendant's opposition to Lively's motion for spoliation sanctions. We've got the Declaration of Ellen Garofalo, Exhibit 21, and the Memorandum of Law in opposition to Lively's motion for sanctions at Exhibit 21. Not relevant to the performance. Third-party plaintiff Abel's opposition to Jones Works' motion for spoliation sanctions. You've got a Declaration of Garofalo again, Exhibit 32, and the Memorandum of Law in opposition to Jones Works' motion for sanctions. 11, not relevant. Okay, that's just a quick summary. So, the court should permanently seal the SPE material. The mere filing of a paper or document with the court is sufficient to render that paper a judicial document subject to the right for public access. Instead, the item filed must be relevant to the performance of the judicial function in order for it to be designated a judicial document. A document is relevant to the performance of the judicial function if it would reasonably have the tendency to influence a district court's ruling on a motion or in the exercise of its supervisory powers. If the documents sought to be sealed are not relevant to the performance of the judicial function, no presumption of public access attaches. If the presumption of public access applies, continued sealing of documents is justified when necessary to preserve higher values, provided the sealing order is narrowly tailored to achieve that aim. As this court has recognized, such higher values include protecting significant, substantial privacy interests such as the physical safety of litigants, witnesses, or third parties, as well as protecting confidential commercial information. None of the SPE material, a narrowly tailored subset of SPE produced information designated as attorney's eyes only under the protective order, is relevant to the performance of the court's judicial function. For the reasons explained below, the SPE material should play no role in this court's exercise of its Article 3 duties in resolving the motions for summary judgment and sanctions with which the SPE material was filed. Even if it did, any role would be negligible with a low presumption of access, outweighed by 1. the privacy interests of non-party individuals' employees, and 2. SPE commercial interests in the highly sensitive financial terms of its contract with Wayfarer that would irreparably harm SPE if disclosed. SPE has judiciously narrowed its sealing request to the greatest extent possible in seeking to protect its private interests and those of its employees. Shapiro Declaration. This is sensitive deposition testimony of an SPE employee that is not cited in any party's filings. The testimony SPE seeks to redact on page 296 was included with the Wayfarer party's motion for summary judgment only because it exists on the same page as other testimony the Wayfarer party cited and which SPE is not seeking to permanently seal. The testimony SPE seek to redact on page 236 is not cited in the party's motions. The redacted testimony therefore cannot possibly have any relevance to the judicial function. The only ostensible basis to unseal such testimony would be to gratify private spite or promote public scandal in private third-party discourse, further supporting that it should be permanently sealed. Shapiro Declaration, Rule 56.1 Statement, Memorandum of Law, Lively Counter Rule 56.1. Exhibit 23 is a co-financing, co-production and distribution agreement between SPE affiliate Columbia Pictures Industry and certain of the Wayfarer parties, part of which is quoted in the Wayfarer Parties Memorandum of Law and Rule 56.1 Statement. The exhibit contains extremely sensitive financial and distribution terms that SPE treats as strictly confidential to preserve its competitive position in the film and television industry. Public disclosure of these terms would materially harm SPE by allowing competitors and counterparties to potentially exploit the agreement in future negotiations. That is precisely why the agreement is subject to a strict confidentiality provision, as is customary with SPE's financing, production and distribution agreements, and such agreements in the industry writ large. The agreement's terms are confidential, commercial information and trade secrets of the type courts in this circuit routinely seal permanently. The Wayfarer parties consent to the sealing of this document, and SPE understand Wayfarer will also be moving to seal this document. The court should seal the agreement in full in addition to the specific quotation in the Wayfarer Memorandum at Rule 56.1 Statement, which are immaterial and irrelevant to the resolution of the Wayfarer summary judgment motion. Okay, so that's likely to be sealed. Wayfarer consent to that. There's no mention of whether Lively is having no position or consents or, objects. Shapiro Declaration, Exhibit 120, is a text message thread in which SPE has proposed a targeted redaction over a single text that is not relied upon in the Wayfarer party's summary judgment motion. The document is cited in the Wayfarer party's Rule 56.1 Statement, but in support of a proposition unrelated to the specific message SPE seeks to redact. Exhibit 72 also is a text message thread in which SPE has proposed targeted redactions over text that the Wayfarer parties again do not rely upon for their motion. The document is cited in the Wayfarer party's Rule 56.1 Statement, but in support of a proposition unrelated to the specific messages SPE seeks to redact. Finally, Exhibit 179 is an email chain in which SPE has proposed targeted redactions over specific communications that are not relied upon in the Wayfarer party's summary judgment motion. The document is cited in the Wayfarer party's Rule 56.1 Statement, but again in support of a proposition unrelated to the emails in the chain that SPE seeks to redact. Because SPE's proposed redactions for Exhibits 120, 72, and 179 do not concern matters on which any party is relying in connection with the underlying motions, the redacted material cannot possibly have any relevance to the judicial function. SPE's request that this material remain unredacted should thus be granted. Okay. Shapiro Declaration, Rule 56.1 Statement, Lively Counter Rule 56.1 Statement. Exhibits 196, 197, and 198 are text and email threads cited in paragraph 288 of the party's Rule 56.1 Statements. That paragraph is, in turn, cited once in the background section of Wayfarer's Memorandum of Law. The information is not material to resolution of the summary judgment motion and reflects private emails from non-party employees who were not even deposed in this case, and that lack foundation, context, and are hearsay. Now, I'm wondering if these messages are Ange Giannetti, because I can't remember if she was deposed. I know Someone else was deposed on behalf of SONY, Josh Greenstein. I can't remember if Ange Giannetti was. Privacy interests of those third-party employees who have had no opportunity to explain the inadmissible statements on immaterial matters included only for background, justify permanent sealing of the material underlying the narrowly tailored redactions applied to these documents. The Garofalo Declaration, defendant's response to Lively's motion for sanctions, third-party plaintiff Abel's opposition to Jonesworks' motion for sanctions. Exhibits 21 and 32 to the foregoing Garofalo declarations are the same text message thread in which SPE has proposed targeted redactions over two texts. One word from one text is quoted in one sentence in the background sections of defendant's response to Lively's motion for spoliation sanctions, and in third-party plaintiff Abel's opposition to Jonesworks' motion for sanctions. And the other text is not quoted at all. The entire sentence, which is identical in both memoranda, has no bearing on the two underlying motions for spoliation sanctions or the responses thereto. The texts relate to an inflammatory and irrelevant statement from a non-party employee who was not deposed in this case with no opportunity to explain it. The texts have no foundation, lack context, and are inadmissible, permitting them to be unsealed, especially where it has no bearing on the court's exercise of the judicial function, would improperly antagonize or harass innocent third-party employees with potentially embarrassing conduct. The texts are issues, and the quotes of the text in the background sections of the opposition papers should be permanently sealed. Shapiro Declaration. This email includes the personal phone numbers of non-party SPE employees. SPE seeks to redact those phone numbers to protect the employees' privacy interests. There is no reason for these third-party individuals' personal contact details to be publicly exposed, and that's fair. Gottlieb Declaration. Lively's Counter Rule 56.1 statement. Exhibit 96 is the expert report of Jennifer Freyd, retained by Lively to provide testimony about psychology theory. Is she the Darvo lady? I feel like she might be the Darvo lady. Lively submitted the entire report in opposition to the Wayfarer Party's summary judgment motion, but only specifically cites pages 10 and 16 at paragraph 442 of Lively's Counter Rule 56.1 statement. The proposition at paragraph 442 does not relate to SPE. The report nonetheless discusses SPE policy and describes in detail purported conduct of an SPE employee taken out of context, all of which is completely irrelevant to the underlying motions, as demonstrated by the fact that this material is not cited by Lively in her opposition papers, although Lively cites page 16 at paragraph 442 of her Counter Rule 56.1 statement. The proposition is unrelated to the sentence on page 16 that SPE seeks to redact. In addition, at page 26 of the Exhibit 96, the expert selectively quotes a sentence of an email from an SPE executive to create an inflammatory impression. Oh, they're not happy with Lively's expert. The expert selectively quotes a sentence of an email from an SPE executive to create an inflammatory impression while omitting the subsequent sentence that changes the quote's meaning. But the underlying email the expert is quoting, which reveals the missing context, is not included in the papers, and the executive that wrote the email was not deposed. There was no reason to include this portion or any other portion of Exhibit 96 in Lively's opposition discussed above, beyond the specific portions on which Lively is relying. Well, there's a shock, isn't there? Lively's expert, much like Lively, is selectively including quotes out of context. There's a lot of that going on in this case. Paragraph 572 of Lively's Counter Rule 56.1 statement purports to describe Wayfarer / it ends with us movies conduct, but then includes a gratuitous, unnecessary, and antagonistic reference to an SPE employee and purported SPE conduct. Oof. Paragraphs 122, 123, 138 and 141 and 144 unnecessarily criticize the same SPE employee in a manner irrelevant to the motion. Exhibit 124 is the expert report of Michael Robbins, Ms. Lively's expert on harassment. But he's going to need an expert just to tell her what harassment actually means. Exhibit 17 is a transcript of his deposition. SPE seeks to redact narrowly tailored portions of these two exhibits that unnecessarily criticize the same SPE employee. SPE is not a party to this action and was not responsible for the production of the film. What? But I thought Lively showcased Sony's cut. She kept saying it's Sony's cut and it was Sony's marketing. Sony now saying we're not responsible? Oh. The SPE employee whom the Prey report, Robbins report, and deposition attacked, and whom paragraphs 122, 123, 138, 141, 144, and 572 of the Counter 56.1 statement unnecessarily criticize, is a private person, not a party to this lawsuit. SPE's proposed redactions are narrowly tailored to protect the professional and privacy interests of an SPE employee. Permitting those statements to become public via purported expert testimony opining on this SPE's employee's supposed obligations, where this material is not relevant to Lively's opposition arguments, simply harasses an innocent third party. Oh, well, come on. Would Blake Lively really? Would you really harass innocent third parties who have nothing to do with this case? Yeah, of course you would. Of course you would. In sum, the SPE material has no relevance to the judicial function and implicates the substantial privacy interests of non-parties as well as SPE's private commercial interests that far exceed any possible public interest in access to them. Courts have long declined to allow public access simply to cater to a morbid craving for that which is sensational. A consideration that is especially acute here given the immense public scrutiny of this action. SPE has taken care to tailor its sealing request so as not to seek to seal any more than it believes is necessary to protect SPE and its employees. To the extent the court believes any of SPE's proposed redaction should be narrowed, SPE respectfully requests an opportunity to propose such redactions before any SPE material is unsealed. SPE respectfully submits that the court should grant SPE's sealing request in full and thanks the court for its attention to this matter. That was really good. That was actually a really good filing. I mean, the business commercial side, that's a no-brainer. That I think will definitely be sealed. Whether the communications between the SPE, the SONY employee, who I am assuming is Ange Giannetti, although there was that one text thread where there was a second Sony executive as well, who Tony Vincento, possibly former Sony employee, where they were basically threatening Jamie Heath that remove Baldoni's film by credit, otherwise we don't get Taylor Swift's song. I'm curious to see, because I can understand and see the rationale behind the arguments. However, they have been brought into it, and I do wonder, like, well, why was Ange Giannetti not deposed? I'm assuming she's not been deposed. I cannot remember if she has been deposed. I may be wrong on that. In which case, I will pin it in the comments if that's the case. But I believe that Josh Greenstein was the Sony representative who was deposed. But if Ange Giannetti wasn't deposed, I don't understand why not, unless it's for the purpose of specifically arguing here. Well, you can't, make these messages public because the person who wrote them has not been deposed. So I don't know. But it seems like Wayfair are in agreement with quite a bit of these, these items being sealed. There is nothing about Lively's position on that. However, it is quite this is quite critical of Lively and Lively's expert. So I'm here for that.